Good afternoon and welcome to Leadership. My name is Dr. Kirti Gupta and I will be your host during today's webinar. As you know, leadership convenes dialogues among scholars, policymakers, and industry experts on the cutting edge of policy issues at the intersection of innovation, competition, and intellectual property. Today, we will explore a topic that has been and continues to be at the center of policy debate in the United States, Europe, and many other countries: competition in digital markets. Earlier this year, the European Union adopted the Digital Markets Act, a regulation that imposes several obligations on the largest digital platforms, with the stated goal of making markets more contestable, fairer, and ultimately promote innovation. A similar debate has been ongoing in the United States, although proposals here fall in the domain of antitrust and range from targeted legislation addressing specific issues to revise the entire body of generally applicable antitrust laws. So here's the big question today's webinar explores. Why are the approaches across the Atlantic so different, and what can the US learn from the EU experience? We have with us an excellent panel today. We start with a fireside chat between Michael Kionen, advisor for the DMA at the European Commission, moderated by Leah Nyland of Bloomberg News, followed by a panel discussion with Jean Burris from Spotify, Alexander Distreel from the Center of Regulation in Europe, Professor Marco Ianciti from Harvard Business School, and Amanda Lewis, former attorney at FTC's Bureau of Economics and currently in private practice. And this discussion will be moderated by Olivier Blanchard, an industry analyst from Creative Strategies. Please welcome all the panelists and moderators. Thank you for joining us.
Hello, I'm Leah Nyland, Bloomberg News' antitrust reporter in the US. With me today is Michael Koenig from the European Commission. He is digital advisor for platform regulation. Thank you for joining me.
Thank you for inviting me, and hello to everyone.
Today, we're going to be talking a little bit about the EU's new digital platform regulation, the Digital Markets Act. Michael, can you tell us a little bit about what the EU wanted to do with this regulation and sort of what the motivation behind it was?
Now, let's maybe start with stressing that the vision that we have of online platforms is that they are enormous enablers. They brought tremendous opportunities for both consumers and businesses. But starting from that, in the recent sort of years, there was also indications and a clear consciousness that due to the nature of digital markets, there's a tendency to create very, very big entities in this field, which is related to an effect, which is basically a winner takes it all effect in many areas where digital platforms operate, which you call network effects. And this effect creates very, very powerful companies where positions are very difficult to contest, not least because of huge advantages when it comes to data and the like. And on top of it, many platforms create whole ecosystems of linked services, which makes it then even more difficult, let's say, to penetrate, other alternative and innovative companies to penetrate these areas. And at the same time, you have, due to these tremendous opportunities, you have businesses that depend on large platforms to do their business, who depend on large platforms to reach their clients. And this leads to what I would call like a gatekeeper position, to already use a term that we have in the DMA. So this type of position, where clients are very much dependent on what will happen, allows them also practices to emerge which can be unfair, which can be detrimental to innovation and to choice in the end. Now, typically, we try to address those with antitrust law and competition law enforcement, but it has a number of shortcomings, which is that it often takes a long time, which it goes through all the instances, but also even more importantly, if you want, you need to repeat it's case specific. So you need to take an issue with one company in a specific service But as soon as the same thing pops up in another area, you have to, take it up again and do enforcement on that basis as well. And that's why there was a growing sort of consensus in reports that we saw from all over the world that antitrust law cannot address these issues really effectively. Reports that came out in the EU, in the UK, in the United States, in Australia, and other areas. They all concluded that basically there is a growing issue with very, very large online platforms, and our tools that we have, they are not enough. Now, and this is where the DMA comes in. It tries to create a solution for that, creating a clear set of rules for the largest online gatekeepers, if you want, which are not sort of really based on individual cases. And we try to identify the most problematic practices where dependent businesses may suffer and innovation is cut off, and then really try to address those to open up again these services and reduce the dependency and the potential problems that are created for dependent businesses through these platforms. And we can certainly later on go into some examples of what particular issues we try to pick up. But this is the overall philosophy, is to bring back and bring out the innovation and enabling potential and opportunities that platforms have for all those that work with them, around them, and who benefit from them.
Yeah, this is interesting. So as you mentioned, the EU had brought a number of cases against Google related to somewhat similar practices. So you all view this as a little bit different from the antitrust enforcement, a little bit more like antitrust regulation. Is that more along the lines of what you're saying?
Exactly. So that is the difference. I'm always saying the DMA is inspired by competition law. It complements competition and antitrust law, but it is not competition law in itself. And why is it so? Because it goes, on the one hand, beyond the individual cases. It really takes up and says, well, these are practices that we've seen again and again, and we extrapolate from the individual cases and say, well, just here the harm that a certain practice or a certain problem is generating is so established that we don't have to look into what is the problem, what are the concrete effects in every single case, but we can conclude, and the legislator here concluded that we need rules that apply upfront and not in case by case. So I think to really have upfront rules that companies have to comply with, where I have a clear rule book without also the uncertainties around antitrust investigations and which type of practices are actually picked up and then pursued. The other element is also that we slightly step beyond the pure sort of competition elements. I mentioned questions of fairness also, which are, like in particular in these relationships of big online platforms and dependent businesses that need those as users to guarantee a level of fairness in those business operations, because many of these businesses depend on the big platforms, and therefore that creates also a chance to exploit this dependency.
What are some of the practices that the regulation is zeroing in on?
So let me give you maybe 3 examples. I mean, one is an area where platforms have a dual role in their operations, where they, on the one hand, are sort of the platform itself, but they're also offering their own services on a platform, or own products on a platform. And this obviously allows them, by analyzing the data and the behavior of users in relation to all the other offers on a platform, to use this information to improve their own offers, but also to outperform everybody else, if you want, on the basis of this information. So that's why the DMA has a provision which is, you could call a data silo obligation, so that basically the platform arm and the commercial arm of a company have to keep their data separately and cannot mix it in order to outperform this information, which is only available to them and not to anybody else on the platform. So this is one example. Another one is also related to what you could call like self-preferencing or discrimination, which is if many of these services and platforms, they rank offers from others, and they give a clear indication on what may be more relevant for you than others. And in this, they just have to be fair in applying the criteria how to rank those without tipping this towards their own products or services or for other criteria which are not relevant. So again, injecting this sort of fairness on both sides, which is for the consumer to get the most relevant offers, and also for businesses who have something relevant to offer to be visible. And then maybe the last example is in the whole mobile ecosystem, if you want, where we see many interlinked and intertwined services based on smart devices. And here you see interconnections based on default settings and pre-installations, where device producers or device developers pre-install certain services which are in the same ecosystem. And knowing from our own experience as consumers how lazy we may be to move and to choose, this has a huge impact. This has a huge impact on consumers and consumers' choice. And here we have a number of provisions which open up these choices in some really key areas, even with choice screens, so that users actively, before when they activate their phone, they have to choose what type of service they use in some of the key services like search or like browsers, for example. So again, to open up the possibilities for others to make their offers visible and give users a chance to look at them and also pick them up.
During the discussion about the DMA, there was a little bit of debate over how the EU should define a gatekeeper. Where did you guys end up settling on what a gatekeeper is and how you guys are going to go about determining when a company falls into that category?
Yeah, I think that's a very important concept, because this basically triggers the whole application of the rules that then follow. So the notion of the gatekeeper is a key point, obviously, under the DMA. Now, first of all, I think it's important to stress that every gatekeeper is only brought into scope based on a decision from the Commission. So there is a clear indication, and there is clear legal certainty who is in and who is out, what type of service is covered and what type of service is not covered. So it doesn't apply automatically, and companies will have to guess themselves, am I captured or not? But there is a clear decision that triggers the whole activity and the whole obligations and rules in the DMA. So that is, I think, is an important starting point. And then we identified gatekeepers on the basis of three sort of really key criteria, which are related, on the one hand, that they have to have a significant importance and be active in Europe, across Europe, basically across several parts of Europe. Secondly, they have to be an important gateway between businesses and their clients. And thirdly, they have to have a sufficiently entrenched position, meaning this is not a one-off. This is something which is stable over time. So this is the starting point. And then the DMA operates with presumptions, which are based on certain numerical thresholds, which create a presumption that these three criteria are met. And those are related, on the one hand, to company-related questions like turnover or market capitalization in terms of the impact, in how many countries are they active in Europe, is one big part. For the second one, it is the question of user numbers. So you have to have 45 million end users in the EU and 10,000 business users to come into scope. of this presumption, which then for us is an indication that this is a gateway, an important gateway, if you moderate, if you say, between this type of number of users on both sides. And then thirdly, the entrenchment is a numerical question of three years, where these figures have to be stable or above the thresholds. Now, this is the starting point again, because this is a presumption, and the DMA has a flexibility in both directions. So if you, as a company, you meet the thresholds, then there's a possibility as a company to provide arguments to rebut this presumption by arguing, well, these figures are not telling, they are not really representing the real situation that my service in. I am not a gatekeeper because there are circumstances. So there's a possibility to argue yourself out of this, and the Commission will look into these arguments and then weigh whether indeed the presumption is rebutted. And then on the other hand, companies that do not meet the thresholds, there's a possibility for the Commission to bring those in on the basis of a qualitative, longer market investigation. So where on the basis of an investigation, we conclude that a company, although it doesn't meet the thresholds, it has to be considered a gateway in a particular, again, situation, in a particular service, which has particularities where the figures cannot be achieved, for example, because there are not 10,000 businesses active actually in a certain area, for example. Mm-hmm. But also to say that obviously this is the figures have a certain indicative value. So companies which are way below the figures, are not first on our radar, obviously. And at the same time, if you are above the thresholds by miles, it will also be more difficult to argue why these figures are not telling.
So you said there's going to be this process, but do you guys have an estimate of how many platforms might be designated as gatekeepers?
Yeah, obviously what is the challenge is that some of the figures that we have as a proxy, they are not public in that respect. So in the end, we will only know in the end when we get the notifications, because once a company is above the threshold, it has to notify this fact to us. Then we will really have a clear picture. Roughly what we always say also in our preliminary works and preparatory works is an order of magnitude of 10, maximum 15 companies, which is also very important to stress, we will come from various parts of the world, including from the EU, including from the US, including from China. So I think we will have a mixed population that will be in scope of the DMA.
Great. So let's talk a little bit about how the law is going to be enforced. So the European Commission will be the one sort of charged with enforcing the law. Can you talk a little bit about where we are in the process of adopting the legislation right now, and sort of when these things might start to come into effect?
Yes, so the legislative process is really on its last, well, not even mile, I would say. We will see the final vote in our parliamentary setup next week on the 4th of July. And then towards September, the law is really be sort of published and enters into visibility and into application. But then it will take another 6 months until the notification obligation kicks in. So this brings us to early next year, in spring next year, we will see the first obligations to notify to kick in, which we have roughly 2 months to process. And then the concrete obligations under the DMA will then kick in another 6 months from the designation. So which means that towards the autumn, end of next year, this is when the practices have to be aligned then with the DMA obligations.
And The European Commission is set up so it has a lot of different specialties, but digital platform regulation sort of encompasses a couple different ones. Who within the Commission is actually going to be sort of charged with enforcing the law?
Yeah, you're completely right in stressing that this is a task where we don't underestimate the challenge that is ahead of us, that we are well aware that this requires a very broad skill set that goes beyond the lawyers that draft a law often. Yeah, so that is very clear. So we that is why we, as a starting point, already work together across two different departments of the Commission. On the one hand, my department, which is dealing with digital issues more generally, with technology issues, with content on the one hand, and our partners in the Department for Antitrust and who deal with competition matters. So we work together in the design of the DMA, we work together in negotiating it through the legislative process, and now we will continue to work hand in hand in enforcing it, because we will need to pool the skills that we have on both sides, both in terms of investigation techniques, but on our side, a lot of technological knowledge when it comes to issues around cloud or telecommunication and safety and security issues, cybersecurity, which all will play a big role. On top of that, we are also aware that we will have to draw on outside expertise. So we are setting up, if you want, pools of expertise outside the Commission that we will be able to draw on flexibly when we get into the enforcement work to provide us with expertise when this is necessary to better understand what is really in front of us. So those preparations are well underway, and we want really to be everything ready early next year to start on that basis, and to be able to, as I said, work as a regulator for platforms, because in the end, this is what this entails.
So you mentioned earlier that the EU has brought a number of competition cases so far against some of the digital platforms, and one of the difficulties with that has been in implementing a remedy. So what kind of enforcement mechanisms exist within the law to sort of ensure that these digital platforms sort of do what the regulation wants them to?
Yeah, so I think the first point, which is also important to stress, is that in a way the remedy as such is built in the law. So the law is very specific on what has to be done, what is expected. So this is something which in antitrust you have to make concrete in the individual decision and say, well, this is why this is a problem and this is what we expect from you. But here this is in a way in a more specific way and more detailed way already integrated in the law. And then there are a number of mechanisms to make this work. On the one hand, we are also fully aware that there can be areas where things are not entirely clear on how precisely in practice you do it, you achieve the objective. So, when you talk about, making data available or giving access to data or data portability and these type of issues, there are many things to implement this technically. And here there is a possibility of a process where the potential gatekeepers can address the Commission and ask it for more clarification, for a specification. And then the Commission issues a decision, says, well, this is how we believe you should do it. This is what we call the specification dialogue, because it allows an exchange and really make it clearer on what we expect, what we would expect, and allow those who are in good faith wanting to comply to have clarity and legal certainty. But then will be cases where we disagree and where we will have to conclude that there is no compliance. And here we have, on the one hand, the instrumentarium that we also have in antitrust, which are fines, which go up to 10% of the worldwide turnover of a company. And in the case of repeat infringement, it can even go up to 20. And then we have also a toolbox in case of systematic non-compliance, which is if there is repeat infringement over a certain period of time across various or similar type of obligations. And this then triggers, although it is quite a high threshold, this triggers a new toolbox where we then as a Commission can impose further remedies of a behavioral nature, that certain practices have to be changed. But it also potentially goes into structural measures of separation, restructuring of business, and something which came in and later in the negotiations stage, a possibility to prohibit further acquisitions by a gatekeeper in a certain area. Now, it has to be very clear that this is really very intrusive measures and will be subject to a very, very severe proportionality requirement. But in the end, it is part of the toolbox in case there are really problems with compliance.
And by structural remedies, you mean like breaking up a company?
Well, ultimately, that is built in the possibility. I think what is important is to say that this is not this is still a remedy, which is designed as a remedy. So any structural measure has to be a solution to the problem. It's not like a punishment, if you want, which, now you've infringed 3 times. Okay, well, now we break you up. No, it has to be a issue that you say, like the issues, where you say, well, there seems to be a repeat problem, not being able to comply with the rules, and only a separation of businesses can lead in the end to complying with the rules. That has to be the conclusion, and it has to be a solution for a concrete issue. But overall, it is in the toolbox. But as I said, this is a last resort measure in our view, where also our courts have established very, very high standards.
Great. So in the digital sphere, there are sort of a lot of things at play, not just competition, but also privacy and data security. Can you talk a little bit about how the Commission sort of intends to take those into account when it's making decisions or having dialogue with companies about what they should do?
Yes, indeed. Of course, we are well aware that the DMA is not operating in a completely, greenfield area where nothing around is applicable. To the contrary, it has to insert itself into already a very developed regulatory framework around issues that you just mentioned: data protection, cybersecurity, privacy, all these type of issues. Now, overall, the DMA is designed in a way to say, we complement this, or these rules have to continue to apply, and they will continue to apply. And both gatekeepers, but also companies that profit from the obligations and the rules in the DMA, obviously have to comply with these rules. The DMA is not creating any exemptions or the like. And it is also clear that we do not want to lower any standards that are at the moment established. So in terms of privacy, in terms of cybersecurity. And we have at very specific areas in the DMA concrete references that these arguments can be made and can determine the way in which certain provisions have to be implemented, and that they have to respect these rules. So to give you an example, there's an obligation in the DMA for messenger service providers to offer, that are gatekeepers, to offer interoperability with third parties so that messages could be sent across. But there's a clear caveat that this shall not lower the level of security and privacy. And that means that if the gatekeeper offers encrypted messages, then this has to remain also in the interconnected situation. So if the third party does not offer such possibility, then there will be no interoperability, and the obligation does not apply. So this just to show that at these key areas we really took good care that the DMA will not lower any of these considerations, which are very important.
One of the other big European regulations in the digital sphere is the GDPR. Can you talk a little bit about how you expect the DMA to sort of interact with the GDPR?
Yes, again, we built very much on the GDPR, which remains horizontally applicable. But in certain areas, if you want, reinforced rules that we have in the GDPR. So, for example, I can give you 2 examples. One is that for certain processing of data, in particular in relation to online advertising, reinforced the requirement of consent. In the past, there were other possibilities to process this data without the users really explicitly knowing about it. And here we reinforced it for gatekeepers to explicitly ask for this consent. Another area is that the GDPR already foresees the possibility of portability of data, that I as a consumer can port my data from one data holder to the other. But in practice, that was not very practical because it was a one-off possibility only, as on block. And in the DMA, we say that this portability also has to be possible on a real-time basis, on an ongoing basis, because only then it makes sense to bring in third parties and do something with this data, which now I can port directly and on an ongoing basis. So these are just two examples that we base ourselves on the GDPR. The GDPR has to be respected in the implementation, but we reinforce it in areas where it really brought value added.
Well, great. This has been a very interesting conversation. Definitely thank you for sharing your time with us today. Just to reiterate, when do you expect the regulation to be sort of fully implemented? Next year, next fall, it sounds like?
Yes, I think towards the next fall, end of next year, we will see the concrete results and the DMA being in full application, indeed.
Wonderful. Well, thank you so much for your time, Michael.
Thank you very much again for the opportunity, and thank you very much again.
And now that we've heard the fireside chats, welcome to today's panel on the EU DMA versus US legislative proposals. I'm Olivier Blanchard, your panel moderator today. And in no particular order, let me briefly introduce you to our panel, and then I'll go around the room and have them introduce themselves all over again. First, we have Jean Burris, Director of Global Competition and Policy at Spotify. We also have Alexandre Destrille, Director, Serre Professor at the University of Namur. Amanda Lewis, Partner at Cuneo, Gilbert, and DeLuca LLP. And Marco Ianciti, Professor at Harvard Business School. So Jean, since you were first to draw the lot, go ahead and introduce yourself again if you would, and then just go around the room in any particular order you want.
All right. Again, my name's Jean Burris. I am the Director of Global Competition Policy at Spotify, and we've been working on and supporting some of the legislation that we're going to be talking about today for some time. Prior to my joining Spotify, a big part of my career was spent at Microsoft doing antitrust work, both on defense and as a plaintiff. So have been working on digital platforms for quite a long time.
All right, Alexandre?
Yeah, so beside my academic activity, I'm advising a lot the European agencies. So I participate to a study which led to the DMA, and I'm also now chairing the EU expert group on the platform economy.
All right, Amanda?
Hi, Amanda Lewis. I am, as Olivier mentioned, a partner at the law firm of Cuneo, Gilbert, and LaDuca. Relevant to today's panel, before that, I worked at the Federal Trade Commission for about a decade, the last 3 years of which, a little less than 3 years, I was on detail to the House Judiciary Committee, where I worked on the digital markets investigation and helped author the report and recommendations, and also worked on some of the legislation that we will be discussing today. I also currently serve as a senior policy counsel to the Coalition for App Fairness, which is a supporter of the Open App Markets Act.
And Marco?
Delighted to be here. Marco Ianciti. My day job, as you mentioned, is really at the Harvard Business School, where I've been a professor for about 32 years and really focusing in on strategy and technology across a whole variety of different industries, but with a special focus really on tech companies. So I've been focusing in on technology platforms for a long period of time, wrote a few books on the subject, and worked on this in a variety of different roles. I also started a company called Keystone about 20 years ago, and Keystone is now a couple hundred people, and we're really in the center for many of these matters across the board, and really focusing in on platform strategy, policy, and litigation. And so we've been involved in, I would say, most of the more salient matters in Europe, in the US, and in Asia. And so, as a big disclaimer, I'm actually involved in either directly or through the organization, many of the matters that we're going to be discussing potentially in this part of this.
Excellent. Perfect. Well, let's jump right in. I have some questions prepared for you, and then if during the course of our discussion other questions come up, we'll address those then. So my first question is, the European Union recently passed the Digital Markets Act, the DMA. And as we know, the legislation imposes new obligations on some of the largest digital platforms. Now, in the United States, there seems to be a general consensus that some action is needed. There's still little agreement on what the right measures should be, with proposals ranging from regulations targeting the conduct of a narrow set of companies to suggestions calling for a complete overhaul of generally applicable antitrust laws, which would be pretty drastic. I think I want to start with you, Marco, and then we'll take a feel for what everybody feels about it. But what, in your view, is the best path forward, or perhaps the most realistic for the United States? And I guess a follow-up question that I'm just going to plant in here is, should legislators in the US follow the DMA, or should they focus on narrower, more achievable goals? And we'll discuss the more specifically the American Innovation and Choice Online Act and the Open App Markets Act in more details in a moment. But I just kind of want to start us off with this.
That's great question. And I guess I want to step back for a minute and really think about sort of the broader context around the question to some extent, because we're really in the middle of a very, very broad transformation that has been influencing our economy now for a couple of decades and is continuing to do so going forward. Because of digital transformation, our economy has fundamentally changed. We have these pervasive networks around the internet, mobile and beyond, that are connecting people, connecting companies to each other. And whenever you have networks, those networks will almost mathematically develop hubs. And so the emergence of platforms and the platform economy essentially is if you like, a mathematical and economic consequence of some very profound change that our economy has gone through. And it changes almost everything, in a sense of the way the companies deal with each other, the ways that companies connect with consumers, the way the companies connect with each other is changing fundamentally, and it's changing the power relationships between companies in all kinds of fundamental ways. And this is something that we've been working on and thinking about now for quite a long period of time. So there's a long history in Europe, for example, being stricter around the enforcement of antitrust laws around these platforms with a greater I think, view on potential harm towards other businesses, whereas in the US, I think traditionally we've had more of a view in terms of potential consumer harm and also consumer surplus that some of these economic changes might have affected. And so I think traditionally we've seen more activity in Europe. And the DMA in some ways is really the next phase of this. And it's really interesting in the sense that it really makes some fairly fundamental assumptions about platforms and how platforms should behave. And, it's easy for me to go out there and kind of poke holes in this, in the sense that, at the end of it, platforms are really complicated, incredibly complex. And in order to actually do something about their behavior, one has to make some broad assumptions. And any economist to go out, we can argue about whether they should be this big or less big, or how some may be affected more than others, and how certain activities may be more important in the DMA than others. But it's an interesting step forward in really thinking more proactively about conduct and thinking more proactively about what platforms really should be doing and some harmful behavior. And for example, some of the things identified by the DMA are effectively really problematic. Like self-referencing behavior, for example, is a real challenge, and it can lock out a number of new competitors into an environment. I should say on related issues, I have actually worked on the Epic Apple case as one example, which is sort of one of the current real reference cases around this. And there are, I think, some very strong arguments for opening up the stranglehold that I think some of these platforms, including iOS, really have on companies like Epic, for example, and giving them their ability to select payment systems that make sense. And there's all kinds of back and forth. So it's an interesting setting with all of this. Within that, there are certain things I think that the DMA kind of leaves out a little bit, which one of them really being fundamentally the positive impact that platforms also have on the economy. And this is one thing that I cannot not mention, in the sense that we wouldn't be here in the stage of economic growth that we're in without these same platforms. And there's huge economies that depend on them across the board. And so from that perspective, there are two sides to every issue, but there is a side around the role of platforms in promoting innovation, and how do we make sure that we don't drive harm and adverse impact in doing so. And so from the US perspective, there's really interesting activity in both sides, right? So that there is potentially influencing at the level of the DMA, and maybe providing a more nuanced perspective on what we can actually do by curbing some of the adverse behavior around platforms, and something that considers more carefully issues like network effects, for example, and the actual real strength of platform network effects, as opposed to sort of the idealized behavior, but also kind of works to preserve the kind of innovation that has been fundamental to the US economy in many different ways. And we can all talk about the bad things that platforms do. At the same time, we can all kind of remind ourselves that there's a lot of positive that these things do as well. And so we don't want to perform brain surgery on something that ultimately provides the livelihood for millions of people out there, and makes things better, as well as sometimes creating problems. So I love the idea of a fairly innovative approach to regulation here, in the sense that I think there is a potential to really set a interesting way of looking at the problem that can help drive the good things that platforms do, while at the same time help curb the negative impact that they have at the same time.
Right. So that's going to come down to a question of execution, which
it does. It does. I mean, the execution piece is a big deal on all of this, and it's not always the easiest thing to do from the regulatory perspective, because it's easy to understand that we are creating harm, and it's a little bit harder to figure out how to fix it. But
right. And I'm going to circle back to Amanda on that in a few minutes. Before that, though, I also want to get Jean's opinion on this, because Jean, you kind of have a foot on each side of the Atlantic with this, so you have a unique perspective, as well as someone who has to deal with it in Europe and in the US. So, what are your thoughts on this, and what would you like to add to?
I have experience on both sides of the Atlantic, but I'll also add to that, I've kind of got a history, I think, that speaks to why we've gotten to this particular place right now, with successfully passing legislation in Europe that addresses the behavior of digital platforms. And and that goes back to my tenure at Microsoft, where rules much like what are being imposed under the DMA and what are being proposed within the US and some of this legislation were imposed on the then gatekeeper to the internet in 2002 and beyond that. And to Marco's point of not killing innovation, and that these platforms do a lot of good, these platforms actually, to some degree, exist today because those rules were placed on Microsoft 20 years ago and enabled companies like Google and Apple to thrive on the Windows platform and to grow and to eventually declare independence to some degree from the Windows platform. But to some degree, I think we're at a place in history where these rules are being proposed because we saw that they can work 20 years ago, and they did work for precisely to the benefit of the companies that we're now talking about, who actually have market power today, I think, that far exceeds whatever Microsoft had 20 years ago. So I think we're at this place in history because of our learnings and experience for the last 25 years. The comparing the DMA to what's being proposed now in the United States, I think we've got an ex ante regulatory approach being proposed in Europe, or being soon to be implemented in Europe. And I think what we've got in the United States are a couple of proposals that are, that mix some of the concepts together. The Open App Markets Act is a very specific, targeted I'll call it regulatory approach to the mobile app stores, where there's a market that's been studied and where people tend to agree the markets are a little bit broken and that there are real abuses taking place in those markets. And that piece of legislation takes those on directly in a targeted manner. And then the Choice and Online Innovation Act is broader. It impacts more platforms, and it does so in a way that, that I think to some degree could address behaviors that weren't necessarily captured by the Open App Markets Act with respect to app stores, but also obviously capture other platforms that are operating today. So I think the U.S. approach is a mix of both regulatory and modifications to the antitrust laws. I think those are the two pieces of legislation that have a real chance of finding their way to becoming law in the United States, as opposed to some of the other proposed antitrust reforms that are out there at the moment. These are the two with a real chance, I think, to make progress here.
Okay, so before I go to Amanda on this, I just wanted to get Alexandre's opinion, and I know that you don't want to comment necessarily on U.S. legislation, but on the DMA specifically in Europe. Do you feel that the DMA has perhaps overreached or already sort of threatened some aspects of competition that perhaps it could have more elegantly gotten around?
Yeah, that's a great question, and it's difficult to answer no. We will see in 5 or 10 years. But I think what I can say no is that in a way the DMA is relatively narrow on two aspects. On its scope, it covers a narrow set of platforms. I would have prefer a narrower set even than what we have, but I mean it is supposed to cover between 10 and 15 platforms, so clearly it's a focus law in that regard, but also in terms of what it imposes to those 10 to 15 platforms. We have a list of, I would say, relatively narrow prohibition, which mainly aimed at alleviating that the platform do unfair leverage from one market to another. And to that extent, for instance, if you look at the self-preferencing prohibition, it's much more narrow than what you have in the US bill, because it's only related to ranking, But then it has a number of obligation, access obligation, interoperability obligation, data portability obligation, which are broader, I would say. And in that way, I think the obligation to open platform and data are broader than the prohibition, which are relatively narrow and circumscribed. Now, why we have those broader obligation to open platform and data? It's precisely to help innovation, and to take the point of Marco and what Jean was saying. It's exactly to allow a small platform to plug in, if you want, on the existing gatekeeper, and to be able to innovate, and indeed replicate the kind of the story that was done with Microsoft. Now, of course, you may have a trade-off between the incentive of the existing player and the innovation incentive of the entrants. That's inevitable in a way, and on that, it is true that the DMA favor the innovation incentive of the small player, of the new player, over the innovation incentive of the existing player, if there is a trade-off. Because I don't think there is always a trade-off, but when there is a trade-off, it is clear that a policy choice has been made to say we want to create a path for innovation of the new one. And why? Because we think that maybe and probably it will help the intensity of innovation, but also it will ensure more diverse innovation, because when we talk about innovation, I think we should talk about the intensity, but also the diversity of innovation. And by opening those paths to innovation, I think we would help the diversity. And the last point I wanted to make, because here this conversation is very much around US and EU, but there is this third big players which we should never forget, which is China. And if you look at China, they have also a proposed law, in fact, where there is, which is not yet adopted, but at the same stage, I would say that the US bills, although clearly the political process in China is very different from the US one, but there is also a draft law regulating the big platform, which has a lot of similar obligation and prohibition that you can find in the DMA. So I would say that the three, and that's I think interesting, the three main jurisdictions of the world have let's say, analyze that there are some problems, and to me seems to wanting to go in the same direction. And I think that's very interesting, and it's not so common that the three jurisdictions of the world are, let's say, going in a similar direction.
Right. No, absolutely. We probably need to do another one of these just to focus on China a little bit. Just because of that one point. So Amanda, I'm coming to you now, and let me reiterate the question again, because it's been about 10 minutes since I asked it. But so the path forward, DMA in Europe, DMA-like legislation here, or narrower, more achievable goals for the US, especially given that our antitrust regime here has traditionally been different from that of Europe. What are your thoughts on that?
Great, thanks. So that is a good question, and there's a lot to unpack there. I think first, I would say that yes, there's definitely been differences in the approach to antitrust law in Europe and the U.S., but I think that in the U.S. there has been an overstatement in characterizing antitrust law from its origins as being only about consumers and price effects. I think from the beginning, and if you look at the history of the antitrust laws, and you'll see that it is not exclusively focused on consumers or price effects. And in fact, if we're talking about protecting competition and enhancing competition, Judge Diane Wood from the Seventh Circuit testified at one of the House Judiciary Committee hearings that, look, you can't have competition without competitors. So I think that there always has been inherent in U.S. antitrust law a sense of focusing on not just the customers, but on other market participants that can be harmed by anti-competitive conduct and anti-competitive combinations. So moving from there, I think you also mentioned that there is a lot of, or perhaps there's disagreement about the different approaches that we could take in the U.S. moving forward. And certainly at the beginning of the process of the digital markets investigation, I think there was a lot more, maybe not even disagreement, but a lot of different approaches that really diverged a lot in different directions. However, since that time, which the investigation was over 16 months, it's been a few years since we did the investigation and drafted the legislation. And really, I think actually there has been a consensus that has arisen. And the two bills that Jean mentioned, the Open App Markets Act and what I refer to as ACOA, because the name is a bit unwieldy, the American Innovation and Online Choice Act, really at this point has quite widespread and bipartisan support in Congress and among voters. So just this morning, there was reporting in The Hill about a poll that mostly focused on swing state voters and went across Republican and Democrat voters. And that poll showed that I think nearly 80% of voters supported the Open App Markets Act. And then with respect to ACOA, it was about 72%. And that is really high for Democrats and Republicans and independents to agree on something, especially in today's climate. So I think there's just quite a lot of consensus. And so when you say sort of what is a realistic path forward, I think there really is a very strong and realistic path forward for both of these bills.
Okay. Well, let me keep you engaged since I have you on already. I think it's a good segue into my second question, which is All right, so the legislative proposals presented in the United States, which you just kind of outlined a little bit. So you have the American Innovation and Choice Online Act, which is a little bit of a mouthful, and the Open App Markets Act, include provisions prohibiting so-called self-preferencing, but also prescribing interoperability, data portability, and sideloading, which in some instances make a lot of sense. But also, some of them might be, I don't say necessarily overreaching, but might kind of put companies in corners when it comes to not only being able to operate like other marketplaces that already exist in the market space, like grocery stores, for instance, or big box retailers, but also might curtail innovation by virtue of the fact that their own markets become a little bit more narrow and not as agile when it comes to interfacing with other services and competitors who also happen to be customers and partners at the same time. So what is your view on these bills specifically? And I know that you've worked on them, but on perhaps the risk that they might go too far, or that they might not be specific enough in terms of addressing the nuances, where essentially you have good outcomes, but you also have bad outcomes, and not necessarily mitigating those differences as well as they could.
So first, I think I'd say that both bills are very, the Open App Markets Act is more specific and more targeted and explicitly really identifies the conduct and the practices that are prohibited, because it's very specific to that one type of marketplace. So that bill is, I think, quite narrow and targeted. And then, of course, Jean can talk about this more later, but there was a lot of thought put into having, making sure that it did strike the right balance between encouraging innovation, opening up the markets. I mean, you talked about narrowing the markets. These bills do exactly the opposite. So I sort of challenge, someone to really show how this would narrow the market. No one is actually even saying that, for example, that Amazon can't keep selling their own products and competing on the marketplace, or that Apple can't continue to offer Apple Music. So this is not about narrowing the markets. This is about opening up the markets and giving consumers more choice. I think just turning then to the ACOA, that bill certainly does have broader and more prohibitions in the list of sort of ex-ante prohibitions. And then it also has a more general kind of backstop, because these companies are very good at finding loopholes and ways to design around, so while we haven't seen this in respect to maybe laws, except for in other jurisdictions, but in the U.S., we've certainly seen this in the big tech platforms' response to consent decrees in prior cases and settlement agreements. So that general prohibition really does need to be there, because we cannot predict every single way in which these companies may exercise their market power. But for that bill, this has been, the discussion has probably been even more expensive, just because it's a little more complex and there's more going on in terms of really making sure that there were adequate affirmative defenses and protections for the companies to engage in conduct that is not anti-competitive and that actually may be good for consumers.
Okay, fair. Jean?
Yeah, I was going to say to play on your analogy to grocery stores. I mean, I think the App Store bill does strike exactly the right balance in that it doesn't prohibit any of the platforms from mounting their own competitive solutions in any particular market. It simply makes sure that they won't take unfair advantage of their platform dominance in those markets. to your grocery store analogy, and there may be another panel down the road where you can speak to the problems of consolidation in U.S. grocery stores and whether that's a problem or not. But it's the difference between having a Safeway, having a Kroger and a Safeway and something else within a particular neighborhood, so it's not particularly an issue, versus, you know, the App Store, that's it. You buy an iPhone, there's only one grocery store in town. And so the fact that some of these, you know, prohibitions are being imposed on the app stores, or some of the obligations are being imposed on the app store, is because it's the only grocery store, as opposed to, you know, presumably you would have competing grocery stores. And to some degree, you know, the Open App Markets Act actually will create the opportunity for competing grocery stores to appear on your iPhone. So.
Right. Fair. No, I think one of the things that came to mind in some of the prep that I did for this, and some of the discussions that I've had over the last year about this, was sort of like when a grocery store. So in the case of Amazon, for instance, just, you know, random example, Amazon essentially doing research on some of the products that are sold through its marketplace, and then deciding, well, okay, we need to make our own, sell our own, and we're going to price it a little bit lower than everybody else's, and we know exactly how to market it. So on the one hand, you know, preferencing its search engines and making its products come up at the top of a search engine is one issue. The other one is the fact that by doing so, Amazon would presumably be creating more competition, right? Because it's bringing another option to the market, and also helping keeping prices down by exerting downward price pressure on the entire product category, which would then benefit consumers. So it's kind of, you know, that's one of the discussions out there, and one of the debates, I guess, that we're having about how, on the one hand, you could help protect competition, but at the same time also threaten it potentially. And I don't know if Amanda's got her hand up. Let me let Jean answer that first, and I'll come right back to you.
Yeah. So I mean, I think the quick answer to that is nothing that's being proposed prevents Amazon from offering their own house brands. And nor would it prevent those house brands from rising to the top of rankings if they truly are lower priced. I mean, if the ranking algorithm is based purely on price and they appear at the top, so be it. What it does prohibit is from them kind of taking special positions within those rankings to promote their products. I mean, so it lets them compete, but it just lets them compete on the same level playing field with every other possible brand that's out there.
Perfect. Amanda?
Yeah, so I would add, I think I've certainly heard this argument before. I think it is a very different situation when you are talking about a supermarket, a grocery store that has a very different relation with its vendors, right? With the manufacturers whose products sell on its shelves in competition with the grocery store's private label. That is a very different relationship that a retailer, you know, certainly a grocery store, has with their with the providers of the products that are competing with their private label than the relationship that Amazon has with its third-party sellers. Amazon has monopoly power over its third-party sellers, and there's extensive evidence of this in the 450-page report that the House Judiciary Committee put out that I did help write, and that also came up in a number of our hearings. I spoke to countless third-party sellers who were able to back it up with evidence that they could not continue to stay in business and reach their customers unless they sold on Amazon. They couldn't cobble together some other way of selling, whether on Walmart.com or on their own website. It's not viable. So that relationship is different. And then some would say, like, there are certainly relationships where you might see, you know, a company like Walmart or another retailer that would have significant market power, perhaps over a producer of something that they would sell at the store. But I would still, again, go back to something that Marco said, something about that I think is, you know, on point. And be interested if he has more on this, but the online markets and the digital markets, it's a different animal. So I just add the other thing is that Amazon, with their third-party sellers, they have access to all of that third-party sellers' confidential, sort of sensitive business information that those third-party sellers would never share with a competitor voluntarily, but they are forced to share that information and have Amazon have complete visibility into their their operations, and then use all of that information to compete with them. And that is different. I've heard it. I think it was Chairman Cicilline who said at a hearing once that what we're talking about in these digital markets is almost the equivalent of saying that that these third-party sellers or some of these other business users that rely on the platforms, that they should just be absolutely fine with having to allow one of their biggest competitors to act as a spy on their factory floor. Like that is the level of detail and competitively sensitive information that we're talking about that these platforms have access to, and essentially force the business users that depend on their platforms to allow them to have access to, that they would not have in a competitive market.
Right. No, that's fair. And I'm coming to you, Marco, in a couple of minutes, but let me do a quick follow up. And I don't like to play devil's advocate because that's just so overused and annoying. But I do want to just throw this out there for you, Amanda. Is it really that there's a difference between online platforms and traditional retailers who are becoming online platforms and online retailers as well? And essentially, what this isn't so much a matter of these particular types of platforms being dominant and being different. It's just that the access to data and data analysis and data crunching has changed. And they're just in the forefront of this digital transformation that's impacting all markets. And so is it unfair to target them because they've been the fastest to adopt it and to be successful using it, while we don't necessarily target other types of businesses that are doing the same thing but are just slower to get there?
So first of all, I don't think that this is a case of targeting the platforms because they've been successful at something. First of all, a lot of the market power and where they got to where they are was done through anti-competitive acquisitions and also through anti-competitive conduct that allowed them to maintain and expand their monopoly power into other markets. So, but putting that aside, I do think that most of these companies have been successful on their own, to a certain degree, on their own merits of their products and services, and they certainly deserve to profit from that, and they have significantly. But I think the question here is not are we targeting these companies because they're successful. I think there is this is another thing that we've encountered a lot, or an argument I've encountered a lot, which is if it's a good rule, why shouldn't it apply to everyone? So if the rule applies to the gatekeeper platforms, why shouldn't it also apply to Etsy or your neighborhood supermarket? And the difference, and that is consistent with antitrust law, is that there can be many things that a company that doesn't have monopoly power or doesn't have market power does. They can be doing the same thing that a company that does have monopoly power is doing. And in one instance, it's pro-competitive. And in the other instance, it's anti-competitive. And so what we're focused on is where are they now in terms of their market power and their durable market power that we're just at a point where we're saying we can't continue like this. We need to inject and promote competition in digital markets. And so I'll turn it over to Gene.
Yeah, I add one thing to that. I mean, I think the access to data is because of their market power, not because they were smarter about getting ahead of the curve on accessing competitors' data. There is no other commercial relationship that I know of where that kind of power could be exercised. Like every commercial relationship, distributor, supplier, whatever the case may be, you often negotiate terms of access to information about the other guy's business and that sort of thing, but those are negotiable terms. This one, I mean, our biggest competitor is Apple Music, and we're in a position where we're obligated, because it's a term and condition of distribution on the App Store, to let them have access to all of our most competitively sensitive information. That's not something we would ever agree to were it a negotiated deal.
Right. Fair enough. Marco, thoughts?
Oh my God, lots and lots of thoughts.
Okay, you have 3 minutes because I've got to move on.
3 minutes. I don't know. I think like 30. I think I need. No, I mean, fantastic stuff. I mean, back to kind of Amanda's comments. So the Amazon story is one that's very close to me because we actually did some of the first research on this, something around 10 years ago. An old grad student of mine, now colleague at Harvard Business School called Feng Zhu, actually wrote a paper that showed that he scraped a bunch of Amazon pages and showed that in fact that those categories that were being fulfilled by partners that had the best characteristics were ones that, lo and behold, Amazon would be offering its own products, more likely, I should say, to be offering its own products relatively short time thereafter. And that paper was very controversial at the time. We thought we were right. Amazon thought we were wrong. But it's a fascinating thing, and it all kind of revolves around situations where Amazon is a huge enabler of commerce through a third-party marketplace. Like we have a case study on this little company in New Hampshire called Xfire. It's a great little case study, a tiny little company, $2 million small business thing, somewhere in New Hampshire, 2 stores. Post their products on Amazon, all of a sudden their sales go up by a factor of 4, like 4x. And then all of a sudden, lo and behold, Amazon is picking up some of its own products, and it's a beautiful case study because like it's literally poetry. You have this little kid that's sort of running the store that his dad's business started, and it's like, why are they kind of stealing my things? But on the other hand, the other side of the story is that their revenues are 4x what they used to be. And they're all online. And, there is an interesting question of like, what data is Amazon actually using? And I think that's kind of fascinating because in a way, I mean, the products are going through the Amazon channel. They're being fulfilled by Amazon. And so it's kind of like the box is going through the Walmart retail store, and all the Walmart people would have to do is open their eyes and see the box flows through, put a little ticker in there, and they have the data. So it's not clear whose data that really is, at least to me. Maybe I'm naive about this, but if I am commercializing something through the Harvard Business School bookstore, and I'm saying I'm selling 300 books through that data in some ways is the Harvard Business School's bookstore's data, as it might be the book publisher's data on the other hand. So there's some interesting questions in there in how you really do this. There's also all kinds of fascinating questions when you come down to the issue of competition and multi-homing. And this is where, again, it becomes, I apologize for being an academic, but it's just academically interesting, right? So like, why does Amazon lower price? Okay. And I have this discussion in class all the time. And it's like, I mean, if there's so much market power, why do they keep lowering price? And they're all like, they have Jeff Bezos as this long-term evil thing that he wants to go and take everybody else out of business, and eventually they will raise price. I mean, but they've been at it for decades, and why aren't they raising price now if they can?
They do.
And the answer to that is not a lot. Not a lot. I mean, we've looked at this pretty broadly, and it's pretty cheap to buy stuff on Amazon. I mean, it is possible. I mean, obviously, but the biggest complaint on Amazon is that we'll sell below MAP, and then people get really upset about that. And so that you're the expert, Amanda, so maybe I'm completely wrong. And But it does feel to me that very often they're still a pretty low price competitor. Maybe they're not the lowest priced overall, but they certainly provide a fairly good deal. And often they get into hot water because the price is too low, not because the price is too high. And people get upset because it's below the minimum advertised price. We have this great video from this knife manufacturer who complains about that. But the issue is, like, why do we keep lowering price? And the issue, fundamentally, I think the answer to that is that they don't have an option not to, right? This is a pretty competitive market. I mean, if I want to go out there and buy a knife, I have a lot of options, right? And so Amazon is one option. And I know Amanda has to be next on this one. But I don't think competition is completely out of it. Similarly, just because you're a platform and have huge share doesn't mean the competition is not there. Like, in my favorite example there is Uber, right? And Uber is the only company that I've ever seen that, in its own prospectus, actually there is a clause in there that says we may never make money in our entire future ever, right? And fundamentally, the reason for this is rampant multi-homing. Even though there is no one that has as large a share as Uber, everybody tends to have 2 apps on their phone at least, and they can still get a taxi cab. And that's because the scale advantages are not that large. Again, with Amazon, they will try to do everything possible to get an advantage. The whole Prime program is about trying to fight this, right? And to try to eke out a profit there. But they're not that profitable in retail. And you got to start asking yourself why that is. And maybe they're mismanaging it, but they seem to be pretty efficient. And so it's a little more subtle, right? So there is definitely competition going on. Multi-homing is a huge issue. I mean, the reason why Google and Apple, for example, are in a different class when it comes down, and the App Store questions, Gene, that you were talking about are fundamentally different there, is because there's no alternative. People don't multi-home on phones. Like, how many people do you know that both have an iPhone and an Android phone? It doesn't happen a whole lot. And so there is no multi-home, and there isn't fundamentally no competition there for that same consumer. And so unless you have multiple app stores, you have no options. If I'm out there trying to figure out if I want to buy socks and I want to, buy them on Amazon, I can buy them on Walmart, I can buy them on a myriad of different websites or retailers, which are still competing with as far as I can tell, still competing in many ways with an online provider. So anyway, sorry about all the crazy stuff, but I think you better go back to Amanda. Otherwise,
I'll try to make this brief. But while I agree with Marco on the App Store issue. I think that is certainly more clear cut that there are parallel monopolies there for Google and Apple. With Amazon, I am not saying that Amazon is the only retailer that exists. There are certainly other retailers, and there are certainly other e-retailers, places where you can buy things online and have the products delivered to your door. So, but I will say that Amazon has an extremely large market share in e-commerce, and that is what gives it monopoly power over the third-party sellers. So that is a large of the focus for me of their monopoly power, because you might say, okay, you can go to Walmart.com and buy a single pair of socks. I don't know if you've tried. I have tried Walmart.com. I have tried to switch. No offense to Walmart. It's not a good alternative. They don't do it as well. And, look, they've been trying with all of their resources for a long time. Some of it, I think, is due to Amazon's anti-competitive conduct, blocking sellers from multi-homing or blocking sellers from selling on Walmart and partnering with them and offering discounts to try to get people to try, a new platform, a new product. But so I think one of the issues is that the consumer yourself, maybe you have more options. I really don't, the research that I've done and the work that I've done leads me to believe that the third-party sellers do not really have other options. And then finally, I would just say, in terms of on the price front and the fact that Amazon maybe typically does have the lowest price, but not always. They, for a while, they formally had a fair pricing policy that they enforced, and I believe they still informally enforce a policy that basically said that if they find a third-party seller offering a lower price on another website or on their own website or at a retail store, that third-party seller will find themselves potentially kicked off the platform, delisted, so they don't show up in search results. And so that is, that is certainly one explanation for the lower prices. But I'm sure we want to talk about some other things. So I will leave it at that, and we may just agree to disagree on some of this and continue to have this conversation at another time.
I have a super quick little thing. No, because I agree with Amanda. I mean, I agree with you. I mean, fundamentally, because like to do these kinds of things, that we found them, right? So they're examples, individual examples of behavior that when you look at it with a certain lens, it looks like it's anti-competitive. And the extent to which that happens, though, is kind of an interesting question, and why that happens is another interesting question, right? So if fundamentally they can't raise price, what is the end game in this? And are they just responding to what they feel is a fiercely competitive environment, and sometimes doing stupid things? And companies can do stupid things sometimes because they will hire Harvard MBAs who I know and love dearly, who sometimes do stupid things because the thing they care about is the SOC category. And from their perspective, that's a real problem. So should Amazon be doing a better job of enforcing its own policies inside the organization? Or is there a real structural problem in what they do across the board, right? Because like you can imagine that same, so you can find exceptions for two reasons. I mean, one of them is just agency, right? They usually have some idiot who's out there not really following the global rules that's out there, kind of getting out of this because their own performance depends on doing well in that specific category. And so moving about, but then overall, sort of the corporation is trying sort of in some ways to just be a fierce competitor, but not doing that illegally. And so there's an interesting question as to why that happens. And I've looked at this for a while, and to be honest, I can't really figure out the difference. I don't know if there's some kind of evil senior presence in Amazon that's trying to figure out how to do this.
Yeah.
But if there is, the first question is like, why aren't they raising price at least more broadly than I can see that before? Or is it just a bunch of idiots that are doing stupid things? Like, bang.
Yeah. My sense is that they do make high margins on certain products, and we did cover this a bit in the report because we were looking into this. But there is a benefit to having the consumers locked into the Amazon ecosystem. And there are a lot of customers who do not price shop. They begin their searches for products on Amazon and end it there. But I hear what you're saying, and I do think it's interesting to look into that further and try to get to the bottom of it.
Right. Having loss leaders is nothing new, and Amazon also has Prime, which it can focus on instead of actual product pricing as a premium feature or outcome. So I have a question about M&As because it came up earlier, but I'm going to sideline that for a couple of minutes. If we could very briefly speak about enforcement real quick. Because the last portion of this discussion that we just had dealt with, why doesn't Amazon do this? Why doesn't Amazon regulate XYZ? And obviously, with this new legislation, there would have to be a question of enforcement. Who enforces it and how? On the one hand, you have the courts. On the other hand, you have agencies like FTC and DOJ. I guess we haven't heard from Jean in a while, but Amanda, since you're also the resident expert on this, both of you, but Amanda first, what type of enforcement can we hope to see with the American Innovation and Choice Online Act and the other one? What's the regime for that, or the proposed regime for that?
Right. So for ACOA, the enforcers would be the Department of Justice, the Federal Trade Commission, and then state attorneys general. So you have your enforcement regime there. Certainly, those agencies would need to have the resources to bring enforcement actions, and neither of these bills are entirely self-executing. So, and I think you're likely to see more litigation with respect to ACOA. But I guess I would just also add that, certainly under the current leadership of Chair Khan, at the FTC, and Jonathan Cantor at the DOJ, I think both have been very bold and aggressive and signaled that they are looking to rein in the big tech companies' monopoly power. They're trying to in current litigation. The current antitrust law is really has a lot of shortcomings at this point. But I think if these bills are passed, and I hope that they are both passed in the very near future, that we can expect to see some fairly quick enforcement efforts at least initiated. But I'm going to turn it over to Jean to talk about the App Store bill.
Yeah, and so the App Store bill has similar jurisdiction, at least for enforcement, DOJ, FTC, and the state AGs that will have authority to enforce. I think it probably is a lot less resource intensive probably to bring a case under the App Store bill, just because of its specificity and its clear application, I think, to certain companies and to particular behaviors. So I think to some degree it might be more self-executing, in that we would, because the violations are so obvious, you probably will see a lot more. That's not to say that you won't see defiance by some of the companies and the desire to litigate it on whatever grounds they think they can. And then the App Store bill also has a limited private right of action for impacted developers. So a company like Spotify could actually bring a case directly under that, to the extent they're impacted by any violations of it. So I think you will see that the agencies are anxious to deploy new tools because of, I'd say, at least under the current leadership, frustration with the limitations on what they can do under current antitrust litigation, and so they will be anxious to deploy those new tools. And then I think it's likely that you'll see some individual developers bring cases under the App Store bill, to the extent to the extent you don't see immediate compliance by the companies, that you'll see litigation pretty quickly.
Right. In terms of velocity, what are we talking about? Because obviously, is there injunctive relief involved in this, or like what's the pace of that type of decision once a complaint is made?
So I think a lot faster than you currently see under antitrust litigation, which is fraught with a lot more questions that need to be litigated. So take the App Store bill. There are a lot fewer questions that need to be litigated on things like market definition and market power and damages and everything else. There are preliminary injunctions available too, but the pace of litigation will be much faster and much more certain, I think, than what you see under current antitrust litigation, which I think is why we are here both in the US and in Europe in seeing this kind of legislation emerge, is because of some of the realizations of what the realities of antitrust litigation are and how long it takes and how uncertain it is. I mean, some of these issues have literally been litigated for a decade and still have not been resolved, and may not be resolved fully for another decade. And I think the legislation that's being passed will provide a much clearer path to a speedier resolution.
Right. All right. Let me go back to Alexandre real quick, because I feel like we've sort of forgotten about him because we're talking about U.S. legislation so much. So we only have a few minutes left today, and I have so many more questions. So we're going to have to do another one of these at some point soon and to get to those. But I wanted to talk specifically about mergers and acquisitions, if we could, because it's a topic that came up earlier that's also super important when it comes to this, when it comes to competition and growth and innovation. And obviously, everybody on this panel may not have the same views on how mergers and acquisitions may be competitive or anti-competitive and who they benefit ultimately and why. But I think it'd be interesting to get a European perspective on this. So the discussion around digital platforms often focuses on how some of their practices undermine the ability of smaller companies to grow and succeed, as opposed to being a channel for acquisition, which is perhaps for some of these platforms, their path to success. So M&As are certainly an important way for small businesses to grow and achieve the necessary scale to be able to compete with large incumbents. But anti-M&A sentiment among many U.S. lawmakers could create new hurdles for companies looking to grow through the mergers and acquisitions process, and therefore make it more difficult to compete effectively against larger established digital platforms. I know it seems like a paradox, but it's reality for a lot of these companies. Now, in the EU, there seems to be a more nuanced approach. The DMA has specific regulatory provisions for M&A that concerns gatekeepers, but otherwise have no impact on mergers and acquisitions. I wonder if, Alexandre, you could speak to this really quickly. We only have about 5 or 6 minutes left. I want to get you, give you the opportunity to speak first, and then I'll go through other participants for their opinions, and then we'll go to closing comments.
Yeah, thanks a lot. So indeed, the DMA do not really change very much the merger control system in the EU. It has two small provisions, but which will not, I think, be extremely significant. One is about more information about those acquisitions by the gatekeeper, even if they are quite small startups, which are normally not notifiable. And then also, if a gatekeeper systematically violates the DMA, then there is a possibility to impose a merger ban for a certain period to the gatekeeper, but only in case of 3 violations in 8 years. So there is no fundamental rethinking of the merger control, but I think there is not necessarily a need for it, because the merger control in Europe is much stricter than it is in the US, in the sense that we prohibit vertical merger, and we have even prohibit conglomerate merger, in Europe, while it's clearly much more difficult in the US. So I think the situation is a little bit different. Having said that, I think one of the big challenge for merger control is in the digital environment is how to deal with deep uncertainty, because there is a deep uncertainty for everyone, for the agencies, for the acquirer, for the company which is acquired. And I think we may need to think about more flexibility in the remedy or contingent remedy. We could say, okay, if the market unfolds in that direction after 5 years, we will impose a structural separation, but you do it firsthand, So I think we need to be a little bit more imaginative and dynamic in our remedy approach. And the other thing I think is very important when we talk about startup and big tech is how the IP is protecting the innovation of the startup. Because my impression is, if you have an IP which is too weak, which is not protecting, for instance, an interface, it's very easy for a company, for a big company, just to copy the innovation. They don't even need to buy it. And so I think there is also, beyond the merger debate, there is an IP debate which should be run in parallel.
Do you have any thoughts on this? So do you feel that the 2 legislations that we've talked about address the speed or the velocity of that regulatory review in a way that's consistent with the pace of business, for instance, when it comes to M&As, and in a way that's not too restrictive also?
So, and just so I'm clear, you're asking about the current, the 2 bills that we're discussing, and whether they sort of adequately account for the speed with which the kind of digital markets might change or adapt.
Yeah.
So, yes, I think they. I think they both. Well, look, I know the people who are involved in drafting these bills, including myself, for at least one of them. I know how much went into talking to people who were very knowledgeable about these markets. And we had so in addition to talking to businesses that, market participants of all sizes that participate in the digital markets, we had a technologist who was on our team and on our staff full time. We consulted with the economists, we consulted with academics, we consulted with privacy experts, we consulted with cybersecurity experts. So just a lot went into making sure that these bills are equipped to deal with both the challenges and the way that digital markets exist today, and then also thinking about future-proofing them to the extent we can, and allowing for some flexibility to account for changes that will come for the future of these markets. So I guess it's not surprising, but I do think that these bills strike the right balance between setting kind of rules of the road for digital markets that I think are really needed, are really overdue, and are really needed. And but I think they do allow for flexibility, and that we will be better off. That these markets, consumers and businesses will really be better off if these bills are passed.
All right.
I think cool. Jean, it looks like.
Jean, and then Marco, 1 minute each. If you can keep your comments concise.
I'll try to keep it shorter than that. But I mean, neither of the bills take on mergers directly, and neither address change the law with respect to that. I think what they do, however, might have an impact on are the incentives for on to go through with some of the mergers that I think maybe if you think of the ones that currently the regulators might have a little regret for having let through, like YouTube or Instagram or DoubleClick. They probably change the incentives for the platforms to actually make acquisitions like that, because they won't be able to perhaps leverage their platform into making that the sole solution. So it may impact mergers that way. But I think that's really the only thing we'll see on the M&A front, at least from this legislation.
Marco?
I'd try as much as possible never to disagree with Gene, so I'm just going to agree with everything that he said, because he knows a lot more about mergers than I do. So I'll leave it at that.
I should say that my comments did apply to how the bills would adapt to changes on the conduct side.
Right.
They don't affect the mergers.
Okay. Sounds like we may have to have a different panel in a year or so and to discuss that specifically.
Let's see what happens.
Super interesting. Yeah.
So
that went by quickly. So we're at the end of our panel and at the end of our events. So obviously there's a lot more to discuss. We only got through about half of the questions that I had for the panel today. So we're definitely going to have to do a part 2 to this, or a follow-up of some kind. To everyone watching, thank you so much for tuning in and spending some time with us today. To every participant and organizer of this event today, I want to thank you, and thank you for having me also moderate this panel as best I could. And we invite you to click on all the links and save the link to this video and to this event for future reference, because you'll probably want to revisit this at some point when we come back around to this and when this legislation actually goes up for a vote. So again, thank you very much for tuning in, and have a great day.